All right, I believe that we are live. Let me just double check that we've got all of our tech running and our audio and visuals. Let's see. All right, we are good to go. Thank you so much, Greg Anjewierden, for joining us in our Solo Suit webinar this week. Welcome to everybody watching. Thank you so much for being here. We are excited to cover some questions that some of you may have about being sued for debt. We have a really special guest today, Greg Anjewierden. He is an attorney and CEO of Debtbrief. Debtbrief is a company that offers consulting, legal resources, and courses to help people who've been sued for debt. Greg, do you want to take a minute to tell us a little bit more about who you are and Debtbrief?
Yeah, I'm an attorney. I practice in Salt Lake City, Utah. So I have my firm, but then I also have this company, Debtbrief, where we specifically do one-on-one consultations with people that have been sued by debt collectors to kind of teach them how the process goes and what they can expect, and point them towards resources that will help them, like Solo Suit.
Awesome. And how long have you been CEO at Debtbrief?
Oh man, I think we started the company back in 2019, I think. So I don't know, probably about 5 years.
Awesome. So you guys have been fighting the good fight for 5 years.
Yeah, and I've been doing debt collection long before that. I used to, do debt collection on the plaintiff's side, and decided that I wanted much more to help people defend themselves than collect. So I've, I guess, seen the light, so to speak.
Oh, that's awesome. So you've kind of switched teams and now you're fighting for consumer rights. So I think that your expertise and experience is really going to inform a lot of people watching today. And, we'd love to hear more about any stories or experiences you can share working on the plaintiff side or creditor's right side, but also now that you've switched to consumer rights. So you're excited to hear more about that too. I just dropped a link to Debtbrief in the comment section in the chat. So if anyone wants to check out Debtbrief and the services that they offer, please do so. But yeah, with that, we had a couple preliminary questions that we wanted to go over. And so I'm just going to jump right into those. And then anyone who's watching, I see that we've got several people on here. Please go ahead and drop your questions in the chat now, and we'll get to those after these preliminary questions. So Greg, the first question I wanted to go over, which is actually the title of today's webinar, is can you be sued for credit card debt? Can you speak to us on that topic?
Well, what I would say to that is, not only can you be sued for credit card debt, you probably will be sued for credit card debt. Obviously credit card companies are not in the business of just giving away their money, and they've got these super high interest rates for a reason. So I work with a lot of people that end up getting sued for credit card debt. And, it doesn't always happen quickly necessarily. I mean, we could be years down the road where they come after you, and it can kind of happen in a couple of different ways. Some, like I see American Express a lot, sues directly. So you'll get a lawsuit from American Express. And then other credit cards, though, they might, write off that debt and sell it to a third-party debt collector. Some of the big ones that you see, like Midland Funding or LVNV Funding, those kinds of things. And so you may get sued for your credit card debt, but not get sued by the credit card company directly. So yeah, absolutely, you can be sued for credit card debt, and if you have credit card debt, most likely you will be sued.
Yeah, that's interesting. At Solo Suit, a lot of the people who come to us are being sued by these like third parties or debt buyers like LVNV Funding, Midland Credit Management, Portfolio Recovery Associates. I'm sure, Greg, you've heard those names, and many of you watching have probably also heard those names. So it does get kind of complicated because you may be sued for credit card debt, but not by the credit card issuer. So it gets confusing, I think, for a lot of people. But yeah, so it's good to know you can and probably will be sued for credit card debt if you do not pay the debt. The next question I wanted to go over with you, Greg, is what should people do if they are being sued for credit card debt? What's the best step to take?
Well, I think the absolute number one thing you have to do first when you find out you're being sued is file an answer. Obviously, that's, I think, what SoloSuit does best. You've got your tool, that helps people draft and file an answer where you're admitting or denying the allegations against you. So, I think a lot of people, they get sued and they're like, oh, what do I do at this point? And I think most people don't respond. And I talk to a lot of people that get sued and they're just like, this freaks me out. Or they see that it's like LVNV Funding or Portfolio Recovery Associates, and they think, well, I don't know what this is, and they do nothing. But you have to file an answer. Every step you can take to defend yourself or settle the case is predicated on filing that answer first. It just gives you so many more options in defending or discussing settlement. And if you don't file that answer, they're going to get a default judgment against you. And, if you've been served appropriately, you're kind of toast at that point. They've got that judgment, and now it's just a matter of dealing with that judgment rather than defending yourself. So I think absolutely when you get sued for credit card debt, the first thing on your mind should be, when's the deadline to answer, and can I get an answer filed with the court by that time?
Yeah, so I think the deadline is different in every state, but it can be as little as 14 days. I think it's 14 days in Texas. Some states it goes up to about 30, 35 days. So it's important to know the deadline in your state. And if you have questions about the deadline in your state, you can go to solosuit.com. We have resources for all 50 states and the laws and deadlines for each state. But yes, it's definitely important to draft and file an answer. And can you tell us a little bit more about, you mentioned if you don't file an answer, you'll probably have a default judgment entered in the case. Can you tell us what that means? Like, what is a default judgment?
Sure. So what happens is the way our court process works is they file allegations against you. That'll be the complaint that comes with the summons that you get. If you don't respond to that, the court assumes that you don't dispute what they're saying. So you get served, you don't answer. After the 14 days, 21 days, whatever your deadline is, the court says, okay, they're not disputing this, so there's an automatic judgment against you. And I'll tell you what I used to do when I was on the debt collection side is we'd get these default judgments, and then we would add interest to it, and we'd add attorney's fees, and we'd add court costs. And all of a sudden this let's say it's a debt for $5,000, it balloons, and now we have a judgment for $8,000 just because you didn't respond, right? So I think it's the worst case scenario. And then a lot of people come to me and they're like, well, I ignored it and I didn't do anything, and now I've got this judgment. What can I do? It's like, there's not a lot to do at that point. So that's why it's so critical to answer at first, because these default judgments are just really killer.
Yeah. I think that's really important to know, that you can end up actually paying way more than you originally owed if you don't respond. And you can speak probably more to this as an attorney having experience representing creditors in these types of cases. But I think most creditors and debt collectors would rather settle the debt than have to go through the lengthy court process, right? So if you've been sued and you know that you owe the debt, you know that it's valid, and you just want to resolve it, it can be a really good move to reach out to the creditor. Well, in this case, you'd probably contact their attorney, right? And discuss your options, especially if you've faced unexpected life circumstances or life events that have made it hard for you to pay off your debts or make ends meet. Explain this to the attorney, because oftentimes they will work with you. They can maybe cut off that interest charge or attorney costs and fees and try to just get it straight back to the debt that's owed and work on settling and negotiating it. Would you agree that that's something that most creditors and debt collectors would rather do?
Oh, absolutely. I mean, the large percentage. And when I was filing these as a creditor, I would always like to have them call, because there was always wiggle room in what I was asking for, right? So we just talked about, if it's a default judgment, I'm getting the full amount that was owed, plus interest, plus attorney's fees, plus costs in most cases. But if they were to call me, I'm probably offering them a deal that's less than the full amount owed, right? So that's going to be, you're wiping out the attorney's fees, the interest, the costs and all of that stuff. So there's almost always a deal to be had. Now, the most common question I get is, well, what's a fair deal? I mean, it really ranges and it depends on the facts of the case. I see some that will only go down a little. I'll see some that will go down a lot. But none of them will go down if you don't file that answer first and then contact them. One of my other best pieces of advice is a lot of people, they'll be hounded by a debt collector before this lawsuit gets filed in a lot of cases. And then they get sued and their instinct is to call the debt collector, or, if it's one like American Express, they'll call American Express, whoever the contact is there. My recommendation is actually to call the attorney who filed the lawsuit and speak to the attorney directly. That's the person that is usually going to be analyzing the case and determining their strengths and weaknesses. They're going to be giving the advice to their client, who's the debt collector, on whether they should take the deal or not. And quite frankly, when you're on the other side of this, as an attorney for a creditor, you have so many cases that it becomes overwhelming. And if you can get one off your desk quickly, you will try and convince your client to take a little less just to get it off your desk. So if you as a debtor are contacting the plaintiff's attorney, I think that's the person where you're most likely to get a good settlement offer from, as opposed to the creditor directly.
Yes, and at Solo Suit, I've actually made those calls to plaintiffs' attorneys to try to negotiate on behalf of Solo Suit customers, and it, I think they're easier to work with oftentimes than just the creditor itself, especially, and I think in some states it's actually against the law to contact the plaintiff. You have to talk to the attorney that's representing them. So just some things to be aware of if you are considering settling the debt and you just want to resolve it. But that being said, we're 10 minutes in, and I think it'd be a great time now to turn the time over to our viewers and answer some questions that you guys have submitted on the chat. Looks like we've got quite a few, so I'm just going to go through these. And before we do, just want to say that although Greg is an attorney, he's not your attorney. This is not legal advice. It's just legal information and resources. We're trying to help people out and know what their options are. But don't take any of this as specific legal advice to your case. We're trying to speak more on a general, broad level. So just a little disclaimer there before we jump into these questions. But yeah, with that being said, we'll start off with a question from Constant Crypto. Hello, Constant Crypto. It looks like they're asking, how do you respond when an attorney files a motion for you to pay for the arbitration? So, Greg, can you tell us a little bit about what arbitration is, and how to compel arbitration, and then what happens if maybe you realize you're responsible for the fees?
Yeah, I really love this question. So arbitration, a lot of credit card agreements have an arbitration clause in them. So the first thing that you should do, of course, I said, is file an answer, but you also ought to be looking at your specific credit card agreement. And if it has an arbitration clause in it, just do a search of it. Does it talk about arbitration? Then you have a basis to file a motion to compel arbitration. And when you file a motion to compel arbitration, you're basically telling the court, this case should be dismissed from the court because the parties have agreed that any dispute between them needs to be decided by an arbitrator, in other words, a private judge. So if you've ever watched Judge Judy or People's Court, the process of an arbitration is kind of similar to that. It's just both sides going in and telling their story, and the arbitrator decides. The downside to arbitration is, well, it could be a downside or an upside depending on how you think of it. It costs money because somebody has to pay the arbitrator to make the decision, right? So I guess this person has said, well, they've probably filed a motion to compel arbitration, and the plaintiff filed a motion to request that the debtor pay the arbitration costs. So the first thing that I'm going to do in response to that is first figure out, what's my deadline to respond to the motion? In most states, it's going to be probably 10 days to 14 days. And you're going to file an opposition, and you're going to say why you think you shouldn't pay the arbitration costs. Now, What's your basis for arguing that? You're going to go to that arbitration agreement that's in the credit card agreement. It should say who pays the arbitration costs in there. Some of the common things I've seen are, it'll say the costs are split evenly. Some of them will say the credit card company pays. Some of them will say the credit card company will front the cost, but the loser of the case ultimately has to pay. So if the credit card company fronts the cost and wins the arbitration, then you would have to reimburse that. In essence, that amount gets added on to your judgment. The reason why you want to file a motion to compel arbitration is, especially if you have a smaller debt amount, then the plaintiff or the creditor doesn't want to pay for those arbitration costs, so they'll just drop the case. And this is really common. I talk to a lot of people that file a motion to compel arbitration, and then the creditor says, forget it, we don't want to pay those costs. So the creditor in this case is saying, well, we want you to pay it. So look at your arbitration agreement, and if it says that you should not pay it, you're going to provide a copy of that to the court with your opposition to their motion. The other thing you can look at is most states, if not every state, has like an arbitration act that will govern what the laws of arbitration are in your state. So you could look up the laws for arbitration in your state. And in some states, it might say that, the plaintiff bears those costs, or it might say that you bear those costs, or it might say they're split or whatever. And you might be able to use those laws in your argument that you should not pay the arbitration costs.
Okay, so it sounds like it's a very individual basis depending on what your credit card agreement and the arbitration clause within it states. So before you file a motion to compel arbitration, it's probably a good idea to really review that arbitration clause closely so that you're not slapped with the arbitration fees unknowingly before you compel arbitration.
Yeah, and what I always tell people is, there's a lot of resources online that'll just say, file a motion to compel arbitration, and your case will go away. That absolutely does happen. I think it works for smaller debts, and it works for those where your arbitration agreement says that the plaintiff has to bear the cost. But if it's like a really large debt, or that arbitration agreement says that you have to bear the cost, it may not work as well.
Okay, yeah, that's all great information to know. And for anyone who's considering filing a motion to compel arbitration, that's one of the documents that we offer at Solo Suit. So I just dropped a link to file or to make a motion to compel arbitration that's personalized to your case if that's something you want to do. Let's move on to the next question. We've got one from Spinster Cat Lady. They are saying, if I see I have an account in collections on my credit report, but much of the info appears incorrect, like when it was opened, when the last payment was made, etc., what is the best way to get info showing where the payments came from? I don't believe this could be my account. Also showing the account was disputed, resolved, customer disagrees, even though I don't recall ever dealing with them. Portfolio Recovery Associates is who the account is in collections with. Kind of a loaded question.
Yeah, I'll start off by saying I don't do credit repair. So if, to the extent you're asking about, getting this off your credit report, I'm probably not the best person to answer that question. But if you're saying, hey, this is here and I want to dispute that I owe this debt, I think the best way to start is to send the creditor that's listed on your credit report a debt validation or debt verification letter. What that does, and I think you've got this at Solo Suit, right, where they can create a debt verification letter, and what it does is you send them this letter, and it basically says, hey, you've claimed that you have this debt against me. I'm requiring you now under federal law to provide me with validation or proof that I owe this debt. Otherwise, you need to stop any kind of collection or credit reporting efforts against me. So I think it's a really valuable tool that you prepare this letter on Solo Suit, send it to them, and if they send some things back, then you can take a look at it and say, oh, well, maybe this is my debt, or definitely this is not my debt. And if they don't respond, then you can go back to the the credit bureaus and dispute that and get it off of your credit report, or they won't be able to take any legal action against you because they did not provide that verification to you.
Yeah. Great. Yeah. So I dropped a link to create a debt validation letter as well, and we definitely see that that's a great way to get debt collectors to stop contacting people, stop calling, because if they can't validate a debt, then technically they're supposed to stop contacting you. That doesn't mean that they always do stop contacting you, but that's something that you should know about as far as your consumer rights go. If they continue to contact you without validating the debt, they may be in violation of the Fair Debt Collection Practices Act. So yeah, read up on that, because, you know, if a debt collector does violate that act when trying to collect a debt from you, you may be eligible for compensation.
And I'll say it's $1,000 per violation. So I'd send that debt verification letter, debt validation letter. Those terms are kind of synonymous. Send the letter, and then I would take like very good notes and screenshots of times that they contact you, you know, after that without validating the debt. And then, you know, potentially for each one of those times, you could sue them for $1,000.
Great to know. And it's so important to know your rights as a consumer. Yeah, let's move on then to the next question. We've got Doug S. He says, "Hi, I was sued by Discover back in early April and filed an answer within 20 days. It has now been almost 6 months and nothing else has happened with the case. Is there any way I can have it dismissed?"
Okay, so another good question, because I think there's a lot of resources out there that are like, okay, you get sued, file an answer, and then it's like, well, what do you do next? Usually what happens in these cases, let's assume it's not a small claims court case. I'm assuming it's not, because he said it's been 6 months. So with small claims court, they'll usually just set a trial date right away and you have to appear at the trial. But if you go to like your regular state court, they have what's called a discovery period after you file your answer. And it's usually around 6 to 8 months. It depends on your state, so you can look up your court's rules on that. But at this point, it's the parties' opportunity to get information from each other that they can use to prepare for trial. So sometimes it just sits for 6 months, and then, you know, after that discovery period ends, the court will set a trial date. Sometimes they will send you what are called discovery requests. They'll send you things like requests for admission. They'll ask you to admit that you owe the debt. But you can do the same to them. So if you're in this 6 month period, you can send them requests for admission and ask them to admit that you don't owe the debt, or you can send them a request for production of documents that says, you know, send me all the documents that you have, you know, on this case, all of the contracts, all of the statements. You know, there's a Discover card, so send me all of the statements that you have, and you can see and be prepared for trial then as to what they do and don't have. Now, you don't have to do that. So the question, I think, was, how do I get this dismissed? You know, you can always just file a motion to dismiss and ask the court to dismiss it. You've probably got to have a legal basis. So what I would do is look at my court and see what's the time period for discovery. And once that time has passed, I'd file a motion to dismiss and say, this time has passed and they haven't asked for a trial date, so I want it to get dismissed. Now, what probably happens in that case is the court calls the parties in for a hearing and sets a trial date. So it's probably unlikely that you can ask to get the case dismissed. But the other option is to just sit and do nothing. You don't have the burden of proof. You can wait for the court to set a trial date. And so sometimes if the plaintiff doesn't ask for that trial date, the court will just dismiss it one day, just out of the blue. So, you know, sometimes when I was working as a collector, we'd file these cases, we'd just have a lot of them, and you just weren't on top of them. And, you know, just one day you'd get a notice from the court, hey, this case has been dismissed. And then it's like, crap, you know, you blew it on that one. And so that's kind of what you're hoping for, and might be what I would do in your case is sit and wait, but be prepared to go to trial in the event the court sets a trial date.
Yeah, and I would also just add to that, like, be watching your case. You might find that your court has some sort of an online tool that you can check the status of your case. You can also try calling the court clerk to see if any actions have been taken in the case. Just be proactive in trying to know if there has been a trial scheduled or anything of that nature, because sometimes those trials will be set and, you know, maybe the document gets lost in the mail and you're not notified. So just be proactive in checking the status of your case. And I went ahead and dropped some links in the chat again. Another option I would just add to what Greg said is you can, if you want to just get the case dismissed and you know that you owe the debt and you want to settle it, oftentimes debt settlement can be like the best outcome for both the creditor and the debtor. So if that's something that you're interested in, we have a tool at Solo Suit called Solo Settle. It's an online tool that can help you send offers to the attorneys that are suing you to start negotiations to settle your debt. So I dropped a link to that in the chat, and then I also linked to a resource on our blog about how to make a motion to dismiss, as Greg had mentioned that in his answer. Let me
just add to that real quick.
Yeah.
Solo Settle, I think, is a really great tool. I think what you want to be thinking about when you use it is, when do you have the most leverage to negotiate a good settlement? And I think at this time when like you're getting ready for trial, or the case has gone on for months, is a good time, because they are obviously not in a hurry to get this case to a trial. They're not pushing it forward. So this is a time where like maybe they're just, sitting around on this case. It's a good point where you have some leverage to try and negotiate a settlement.
Yeah. So, consider if you actually owe the debt, and if you think you have some sort of a defense in the case, maybe just sit back and wait. But if you just want to get it over with, you want to pay them back, maybe reach out to discuss settlement. Next question is from Jimmy. They say, I received a letter from Scott and Associates on an old Barclays card. I am currently working with a debt settlement company, but I am looking to cancel the contract with them. I also have an attorney representing me as well, and I plan to keep his services just in case. I don't see a question here, but it's good that you're working with an attorney. And Scott and Associates is another one of those like big debt collectors. I think it's actually a debt collection law firm. I don't know, Greg, if you have any experience with Scott and Associates, but I'm going to drop a link to a resource from our blog on how to settle debt with Scott and Associates for your help.
Let me just say this, though. One thing I see a lot is people that work with debt settlement companies. It can be helpful in some situations. A lot of times the debt settlement companies, though, will bail on you when you get sued. And it depends on the company. Some will provide resources and help you with that. But I see a lot of people where they're like, I have this debt settlement company, and they were trying to settle the debt and they couldn't. And then I got sued and they said, you're going to have to, use an attorney or whatever and go out on your own. Just because the debt settlement company couldn't settle the case doesn't mean that you can't settle the case on your own. Because a lot of times places like Scott and Associates, they don't want to negotiate with debt settlement companies because they see them as the enemy, so to speak, and someone that thwarts their efforts to get their money. But they will be more likely to negotiate with you as an individual. So, one thing that you might try is using Solo Settle or contacting them directly yourself and seeing if you can negotiate a settlement if your debt settlement company has not been able to. Because I see a lot of people where they're in that exact situation and they settle it on their own, but they couldn't get their debt settlement company to settle it.
That's really good information to know. I do think it's important to realize that, in this industry, that, typically creditors see debt settlement companies as their enemy, right? Solo Suit is trying to position ourselves as like a mediator between the two parties, between debtors and creditors. And so yeah, that's something to think about. I do think it's important to realize you have a lot of power representing yourself in these types of cases too. Like, you don't have to have an attorney. You don't have to work with a settlement company. You can take matters into your own hands. There are a lot of free resources out there like Debtbrief, Solo Suit. Also, we offer free resources as well, also paid resources. But yeah, you don't have to take the traditional route of like getting legal representation or working with a debt settlement company. Let's see. So we've got a few minutes left. Greg, are you good to go a little bit past 5:30 your time? Okay.
Yep, let's go.
All right. Maybe we can do more rapid fire in the next few questions. Some of them I think cover topics we've already mentioned. So the next one is from Virgo for Freedom. It says, in Ohio, can I file a motion for dismissal with prejudice for want of prosecution, or would it be without prejudice?
Well, so I would always ask for with prejudice, right? Like, if you're asking for a dismissal, you should ask for with prejudice. But typically when I'm in court, Everybody that's asking for a dismissal asks for with prejudice, but you've really got to have a basis for with prejudice. So
can you tell us what with prejudice means?
Yeah, you bet. So with prejudice means the case cannot be refiled. So it's dismissed and it's over for good. Without prejudice means it's dismissed, but if they choose to bring it in the future, they can. Now, if you file a motion to dismiss for lack of prosecution, that's typically a without dismissal or without prejudice dismissal. So the court will dismiss it because they're not prosecuting it, but they'll have the option to bring it again in the future, assuming the statute of limitations hasn't run. So I would definitely ask for it, but be prepared that you might not get it.
Great answer. I did not know the answer to that one, so I learned a lot just now. The next question, not that I'm saying that I know everything, guys. I'm just saying I love doing these because I get to learn with everyone. The next question, though, is from DRBL Wit. I don't know how to say that, but it says, will arbitration help win a case if the balance is under $2,000?
I mean, I can't give you a guarantee, obviously, but I would say under $2,000 is definitely one where I would consider filing a motion to compel arbitration, especially if like we talked about, the arbitration agreement says that they have to bear the cost or the cost is split, because they're almost certainly going to spend more than $2,000 on an arbitrator, right? So if you're under $2,000, they're going to look at that. If they've got to pay the arbitration costs, why would they pay, $2,500 to collect a $2,000 debt? So if I'm under $2,000, I'm probably filing a motion to compel arbitration, depending on the language of my arbitration agreement.
Okay, great. Let's keep going. Oh, by the way, I think that person that asked about the arbitration just now is being sued by LVNV funding, maybe it looks like. Again, very common player in this industry. Let's keep going, though. Let's see. We've got Carlos Rivera says, hi, I have my hearing next Tuesday. I want to settle the case. What should I do at the hearing?
Well, what I would say is if you've got a hearing next Tuesday, you've got a good opportunity to settle the case. So I would be using all of my time between now and Tuesday to, number one, prepare for the hearing, but number two, trying to settle beforehand, right? And so if you're going to use solo settle, you've probably got to do it starting now so that there's some time to make these offers back and forth. But what I'll also add is hearings are actually an excellent time to settle a case, especially if they're in-person hearings rather than virtual hearings. Because what happens, and I'll do this a lot, here at my local court, usually debt collection cases are handled on Wednesday afternoon. So we go over to the courthouse on Wednesday afternoon, and everybody's just kind of in the hall waiting for their case to start, and you're finding each other. And I get so many deals done the hour before my hearings. So I would say try and settle before if you can, just because you've got more time, but show up at that hearing early, try and find the attorney on the other side, ask around, someone will probably know that attorney, and you can try and make a deal right then and there before the hearing starts. If you get it done before the hearing starts, you can walk into your hearing and tell the judge, we got this settled, we don't have this hearing anymore.
That's really good to know. Yeah, I think in my experience, interviewing attorneys, it seems like most debt collectors and debt collection lawyers would rather just avoid going to court altogether. They're just like you, they don't want to spend their day in the court building fighting over a case. They would rather resolve it outside of court.
And I'll tell you, I watch a lot of these hearings while I'm waiting for my cases to come up too. And a lot of times the judge will call a case and the attorney for LVNV funding or Midland funding or whoever walks up there and they says, is the defendant here? And they'll say, yeah, I'm here. And they'll walk up and they'll actually say, Judge, can we postpone this one for 15 minutes? I'd like to talk to them outside. And they go outside in the hall and talk and settle the case. That's really common. So I would definitely try and catch the attorney in the hallway before the hearing starts and try and settle it if you can't get it done beforehand.
Great advice. All right, next question is from Leo. It says, I was summoned in New York City in the county that I live. I went in person to answer the summons and used free attorney service at the court. The attorney was recommending bankruptcy. What are the pros and cons of bankruptcy?
I just think bankruptcy is a really serious decision. that's going to have a lot of impacts on your life for years moving forward, right? And certainly bankruptcy is a good option for a lot of people. What I usually tell people is if you've got a lot of assets that need protecting, or you've got so much debt from so many different creditors that you can't possibly handle it all, then bankruptcy is probably a good option for you. If you've got like one case and it's like one credit card that's suing you, I probably would not file bankruptcy in that case. What I would probably be trying to do is trying to get a settlement done, get it on a payment plan. A lot of these creditors are willing to do payment plans. So certainly bankruptcy is a good option if you've got a lot of debt or a lot of assets. But if it's just like one credit card lawsuit, I'm probably trying to settle that and not filing bankruptcy.
Yeah, and just to add to that, I went ahead and dropped a couple links to some blog posts that we've published on Solo Suits blog. I added one for the pros and cons of chapter 13 and also chapter 7. So check those out. Those might give you some more information too. Let's see, next question. And I think we'll go for another 3 minutes or so. We might not get to all the questions tonight, but we have these webinars weekly. So come join us next week in our webinar. We've got a former debt collection attorney joining. So definitely will be getting great answers like we have received from Greg tonight. Let's see. RH said, I was sued. I sent the answer to the court and sent a stamped copy directly to the credit collector. I asked that they respond in writing only and stop calling. They still call. I also asked that they provide answers to a debt verification letter. They haven't. What are my next steps?
Well, first, you can potentially look and see if they've violated the Fair Debt Collection Practices Act like we've talked about. However, things are a little bit different once you get to court. And I guess I'm not entirely clear by the question of who's calling. So if it's the debt collector themselves that continue to call, that very well may be a violation of the Fair Debt Collection Practices Act if you've stopped them to do that. However, if it's the attorney who's filed the lawsuit that continues to call you, that's probably going to still be allowed. Obviously, caveat being, the rules may be different in your state, but typically the attorney is still going to be allowed to communicate with you by phone on this debt. So the other thing is, a lot of people, after a lawsuit is filed, they'll send the debt verification letter. Debt verification letter is still fine to send after a lawsuit is filed. It's a better tool before a lawsuit is filed. Once a lawsuit is filed, there's other tools within the court rules that can be better than a debt verification letter. Like I talked about earlier, discovery requests. So if your court's rules allow discovery requests, I'd probably be sending discovery requests rather than a debt verification letter at that point. So I don't know, does that answer the question, do you think?
I think it does, yes. Let's do rapid fire on the next few questions and then we'll probably have to wrap things up. Let's see, we have Arnie says, what are some documents that I can ask for from the original creditors? I'm assuming to help with the defense of your case.
Yeah, so I'm assuming you're in the case, you're going to send some discovery requests, right? So I'm always asking for the original contract. Can they prove that you owe this debt? They've got to prove that there's a contract. If it's a credit card, I'm asking for all the statements. And a lot of times what you'll get from them is a single page statement that just says past due balance, right? I want more than that. I want every statement that shows every individual purchase that I made so that I can verify that that amount is correct and that the interest calculation is correct. Now, if it's a third-party debt collector like LVNV or Midland or Portfolio, then I'm also asking for some additional information. I'm asking for the purchase agreement between the original creditor and the third-party debt collector, because the way it works is, if Portfolio Recovery Associates sues you, they have to purchase that debt from, let's say, Discover Card. So they have to purchase it. And so there's got to be a contract between those two where they actually purchase your debt. And so I'm asking for the specific contract that shows that they purchased my debt. And a lot of times they'll just buy these in bulk and it'll just say, we're buying, 500 accounts with account numbers listed here. And you ask that ask for that, you get it back, your name is nowhere on there. Now you've got a really good defense that they haven't purchased your case. So those are sort of the big ones. I mean, there's a lot more you can ask, but just to answer quickly, I'd ask for the original contract, the statements, and then if it's a third-party debt collector, I'm asking for the purchase agreement.
Perfect. I think we've got time for one more question, and then we're going to call it a day. But as I was reading some of the other questions we received, it seems like we touched on a lot of these topics in answering the other questions. So hopefully, we were able to at least help some of you get pointed in the right direction. If you have more questions, reach out to us at support@solosuit.com. You can also check out Greg's website, debtbrief.com. I'm dropping it in the chat one more time. And then, we'll just drop a link to our Solo Suit services. You can go check these out, see if any of those will work for you in your current case situation. Let's take one more question. I'm going to go ahead and read it from Sasha maybe. It says, being sued by Midland for Capital One card. I filed an answer, did mediation, and we did not reach an agreement. Currently waiting for the next step. I sent a debt validation letter and they provided statements and a cover letter stating that they now own the debt and not the original creditor. I guess there's not really a question there, but I'm guessing, Sasha, you want to know like maybe what your next steps could be. Greg, do you have any thoughts on that?
So this is what I was just talking about, right? They send a cover letter that says, oh, we own this debt now. Well, you don't get to just say that you own it. You've got to prove it. So I would send them, if your court rules allow it, a discovery request and actually ask for a copy of the contract that shows that they own it. Again, you sent the debt validation letter, and that's fine, but I would be sending discovery requests to make them verify. You can get a lot more specific with your discovery request. The debt validation letter says, hey, just send me what you think is proof. The discovery request, you can ask for specific documents. So that would probably be my next step, is to send discovery requests. The other thing I would say is, you didn't settle it at mediation. It's very common for cases to not settle early, but settle later as they go on. So just because you haven't settled it now doesn't mean the door is closed on settlement. Case can be settled at any time. Like I said, maybe you didn't settle it at mediation, but as you send these discovery requests, maybe they realize they don't have all the documentation they need, and it sort of reopens the door to those settlement discussions. So I wouldn't give up on settlement yet.
Yeah, and I just want to also echo that we talked about this multiple times, but oftentimes debt collectors, especially debt buyers, will not have the proper documentation that they need to prove that they have the rights to collect the debt and take legal action on it. So that's why it's so powerful to just draft and file an answer in your case, because, in some cases it might get the whole thing dismissed. But even if it doesn't get dismissed, filing an answer gets you closer to settling the debt and resolving it, as opposed to just losing by default judgment and then realizing months later that your wages are being garnished. So yeah, definitely take action if you've been sued. Reach out to us at SoloSuit. If you have any other questions, you can contact Greg again at debtbrief.com. Thank you so much, Greg, for joining today. Do you have any other last thoughts before we close?
Yeah, just one other thing. We got a lot of questions about well, what do I do? I filed the answer, and then what happens? And I've talked a lot about discovery requests, and there have been some questions about that. Up at debtbrief.com, I do have some form discovery requests that people can use, as well as sample discovery requests that you can send them as well. So that's another resource that people can use.
Yeah, perfect. Check it out. The links are in the chat. And thank you all for watching. We had a great turnout tonight. Thanks so much, Greg, for joining us. We'll probably have Greg on again in the coming weeks. But yeah, stay tuned for our webinar next week. We do it weekly on Wednesdays. Thanks so much for watching again, and thanks again to you, Greg. Have a great night, everyone.